Good morning, everyone. Thank you for attending today's workshop. On August 29th, 2025, the clerk's office issued a notice of workshop on site visits and educational tours. And the section that we are discussing today at a minimum is South Carolina Code Annotated Section 58-3-260I. The notice indicates that the workshop today would begin at 9:00 a.m. in the Commission's hearing room. Okay, so what I would like to do now, everyone, is call the names of the stakeholders who indicated that they would participate in today's workshop. And if you would please identify whoever the spokesperson is, yourself and your colleagues if necessary. I'm going to begin with Dominion Energy South Carolina Incorporated.
Good morning, Ms. Boyd. I'm Chad Burgess, and with me is Elizabeth Hutton. We're corporate counsel for Dominion Energy South Carolina. And virtually is Michael Anselmo from the law firm of McGuire Woods, who serves as the company's outside counsel. And Mr. Anselmo will be delivering the bulk of the company's message today. But I anticipated this would be maybe a free flow of discussion, yes. So I'll probably pop in from time to time and share my thoughts as well.
Sure. And should I just call on Mr. Anselmo first when it's
That'd be great.
Sure. All right. Thank you. Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Ms. Boyd. On behalf of the companies MCM Wellborn, with me this morning is Lyle Trawick of the firm Robinson Gray, Estep & Lafitte. Thank you.
Thank you. And Mr. Wellborn, who will be the first speaker from your clients?
Like Dominion, it may be a bit free flow, but I'll plan to be the first speaker,
Yes.
and then we'll go from there.
Okay.
Thank you.
All right. The next, Palmetto Broadband Coalition.
Good morning, Nanette Edwards. I'm here on behalf of the Palmetto Broadband Coalition. Mr. Wright it will not be attending.
Okay, thank you. Carolinas Clean Energy Business Association.
Yes, good morning. This is John Burns. I'm in-house general counsel for CCBA, and I'll be participating on our behalf. I'm not sure if anyone is in the room for us down there, but I'll be handling most of the discussion.
Not yet, Mr. Burns. So right now we'll call on you. I'll let you know if we see
I hope that's acceptable that I'll talk. I appreciate it.
Yes, sir. South Carolina Public Service Authority.
Good morning. Stephen Pelcher here for Santee Cooper, and I see my colleague up on the screen there.
Yes. What should I call on you, Mr. Pelcher?
Edwin Kamala just started.
Okay. Will you speak first for Santee Cooper?
I will.
Okay.
I will. I don't think Edwin will be speaking for us today, and I think we'll be more in a reactive mode as this thing goes forward.
Okay. Perfect. Walmart Incorporated.
Good morning. It's Stephanie Eaton. I'm here for Walmart. Thank you.
Thank you, Ms. Eaton. Nexus Water Company's South Carolina Utilities.
Good morning, Charlie Terraini. I'll be speaking for the companies.
Good morning, Mr. Terraini. South Carolina Department of Consumer Affairs.
Good morning, Ms. Boyd. Roger Hall on behalf of the department.
Thank you. Piedmont Natural Gas Company Incorporated.
Good morning, Ms. Boyd. Jason Richardson with McGuire Woods LLP on behalf of Piedmont Natural Gas.
You said LLP?
I was being too formal for a Friday, sorry. But yeah, McGuire Woods.
No. Oh, you said McGuire Woods. I thought when you said Piedmont Natural Company, we have them listed. It's incorporated. And you said LLP. I was like, when did they change?
No, it's
okay. McGuire Woods is
for an
LLP.
Afternoon person. It's still early. Sorry.
Okay. No problem. All right. Let's see. Southern Environmental Law Center.
Good morning, Dawson. This is Kate Mixon for SCLC. Thomas Gooding is also joining for SCLC virtually.
Okay. Do you want me to call on you first, Ms. Mixon?
Yes, please.
Okay. All right. And then Office of Regulatory Staff, if everybody doesn't mind, I was planning to call on Office of Regulatory Staff last, since no matter what happens, they're going to have to certify the record. Is that okay with everybody? Does anybody object to that? Okay. Office of Regulatory Staff.
Good morning. Ben Muschin on behalf of ORS. With me is our Executive Director, Andrew Bateman.
Thank you, Director Bateman and Deputy Director Muschin. Okay. So let's see. If you recall, I hope everyone received on or around September 11th suggested topics for our workshop today. And They include at a minimum definition of a site visit, definition of educational tour, procedures for the site visit or tour, locations to be visited, attendees, logistics, safety / access, permissible on-site communications, impermissible on-site communications, post-visit summary and 48-hour certifications, and other topics that you all introduced today. So I'd like a little bit of feedback on this strategy. What if we start with Dominion, and Dominion Energy South Carolina provides its initial thoughts about these topics, and then I can either move next to Duke Energy Carolinas and Duke Energy Progress, and like go around and call all the names first of the entities who are present, and then go back to Dominion Energy South Carolina for feedback. Or we can begin with Dominion Energy South Carolina, and then others who want to chime in, I can just go down the list one by one after each, I'm saying presenter, but initial comments. Any thoughts on that process? So we can either all go around one time, and then I go back to Dominion, what Energy South Carolina, what do you think about what Duke said, Piedmont, Walmart? Do it that way. After everyone has had a chance to speak. And then there was like a round of direct and a round of rebuttal. No, it's not rebuttal. I guess direct again. It's really not rebuttal. How do you feel?
Jocelyn, that's fine for Dominion. Others may have other thoughts. I don't intend to rebut anybody today.
Okay. Okay, well, that's what I will do, everyone. Okay, we'll begin with Dominion Energy South Carolina, and we'll listen to their thoughts. And then I'll just move to you, Mr. Wellborn. And then after that, I will move to Ms. Edwards. And then after everyone has an opportunity to speak, I will return to the Dominion Energy South Carolina.
So that sounds great to me.
Okay.
So Jocelyn, just a couple of comments, and then I'll let Michael deliver the company's message. Number one, I don't want to bury the lead at the end of the day.
Mm-hmm.
So I'll start by just stating the company's position that we are of the opinion that a regulation is not necessary to deal with the issues that you've got on your topic list here. I will say that as a regulatory lawyer appearing before the commission, this code section is probably the one that strikes the most fear in my heart among all the code sections that we apply here at the commission. The ex parte statute is it's very prescriptive, and I think that was intentional by the General Assembly to inform the parties, the commissioners, the public, anyone, quite frankly, that there are certain things that are off limits when it comes to communicating with commissioners, and the fact that you have you can't talk about any issue that is pending or may reasonably come before the commission. It really limits the types of discussions that we can have with commissioners outside of a hearing room, which is fine. We've lived under this parameter for a number of years. I think maybe since 05 or 06. So it's been a while. So we've trained ourselves very well to make sure we don't do anything to trip the statute. Act 41 is somewhat of a little sea change. So it's going to take me a little bit of time to get used to and comfortable with being able to do things that maybe we once weren't otherwise allowed to do. Mm-hmm. So in addition to our thought that it's not necessary to implement a regulation because of the prescriptive nature of the statute, it's our position that we probably need to go slow as far as getting our legs under this. I've been trying to think of an analogy that kind of works here, and the only one that really kind of comes to mind is when you're told no, you can't do something for over a decade, and then all of a sudden you wake up the next day and on May the 12th you can say, oh yeah, you could do that now. It's you want to just proceed a little cautiously. Okay. So our position is no reg is necessary, and we think we just need to kind of wade into these waters slowly. At least that's Dominion's perspective on it. Michael, I don't know if you can hear me okay. Hopefully you can. I'll let you continue the conversation.
Yeah, Chad, I can. Thank you. And to explain the company's why we think going slow is the right reason, I can handle that. First, I'd like to thank you all for letting me participate virtually. I am traveling for my wife's annual 29th birthday, so I am remote today, so I appreciate that. As Chad mentioned, the PSC, all the parties here have been living in a world since 2005 in regards to what can and can't be done with the commission outside of a notice docket, a forum, things of that nature, or an allowable ex parte. Act 41 sub I changed the game, but it changed it in a manner different from what used to take place under the allowable ex parte rules. And I will circle back to that part. But if you look at subsection I, as you said, Jocelyn, what we're here for today, the General Assembly has laid out the step-by-step process for a site visit and an educational tour. Site visits, obviously, are for facilities under construction by either a regulated utility or Santee Cooper. Educational tours are allowed for sort of existing, already built facilities or anything really that is owned by a regulated utility or Santee Cooper. I mean, frankly, if you wanted to come check out Chad Burgess's office, I'm sure we could probably make that happen. But the section itself lays out the rules. And as I said, the rules are now different. And here's what's telling about the rules. And I think my comments are going to address your points on a sort of global level. But if you have specific questions, please let me know. If you actually look at the definitional section of 260 sub 4, allowable ex parte briefing and the rules attendant to an allowable ex parte briefing is only defined are the things that are now in subsection D6, which are the traditional ex parte, allowable ex parte briefing rules. If you switch over to that section, the first thing it says is that it's subject to FOIA, and then it lays out the various, Chad said, prescriptive rules around allowable ex parte communications, allowable ex parte briefing, right? None of that changed. But the important part is the General Assembly specifically delineated the applicability of FOIA to these type of procedures. That's why when everybody shows up, ORS has to certify and everybody has to sign in and do all the things they do. But if you look at I, it is a standalone, brand new section that, as I said, specifically, unequivocally, clearly, there's no ambiguity in I, does not link FOIA to a site visit or an educational tour. And that makes intuitive sense. Why is that? Well, it is just a fact that utilities have access and security requirements around their facilities for obvious reason. And not everyone is allowed access to a facility for safety, for FERC rules, federal regulations, etc. And by exempting site visits and educational tours from FOIA, it does allow a controlled environment in which commissioners, staff, and other appropriate parties can come check out in progress CT facility being built, or they could go out to VC Summer and check out operations under an educational tour, and we can show how the facility works. If they wanted to see one of the giant generators that are out there, the backup diesel generators, learn about that on an educational basis, we can do it. But again, it is under a controlled set of rules and access requirements. And that's important because we've had some conversations in other forum about the need for safety and access at utility property. And that addresses, I think, logistics, the safety, the attendees, the locations to be visited. But it is something that, as Chad said, we don't need a reg. I mean, it's 2 pages of what has to happen in order for a site visit to occur. And until really we get our head around how these things are going to work, going slow makes sense. I think nobody wants a regulation to be promulgated that then has to be walked back in short order in front of the General Assembly. That doesn't help the commission, doesn't help the parties when we later go back with needed regulatory revisions or regulation revisions. The summary is site visit, educational tours. Those are easy to understand, clear terms. The process is set out, and the FOIA concerns that are attendant to normal ex parte communication and briefing, et cetera, under sub D simply don't apply here. So let's let the statute breathe. I understand that maybe perhaps some site visits and educational tours are already being proposed to the commission. We should see how those shake out before we maybe box everybody in when it's not necessary. So I'll pause here. Obviously, I can't see everybody. So Jocelyn, if you had any questions for me specifically on your topics, happy to address those.
Okay. Yes, Mr. Burgess mentioned a regulation. So did you, Mr. Anselmo. You don't think that one is needed at this time. Do you recall when the commission created settlement procedures, and they're not included in a commission order or regulation? Do you think a document like that would be helpful as we go through this process? And the second question I was going to ask you, staff has planned a follow-up regulatory process workshop for next June. Would that be, with this topic, just a review, just insight, observations next June, would that be an appropriate agenda item for, I'm saying agenda, but topic for next June when we gather again for you all to say how the commission, where you see improvements and needed in our operations and other suggestions?
Yeah, I think, look, what is that, approximately 9 months from now? I think that is a pretty good time to let this thing breathe and everybody get their head around it and operate under it. As far as the settlement procedures, I understand what you're saying. If the intent behind that is to have some sort of, maybe, I won't say informal, but let's call them temporary initial thoughts and guidelines on how this will operate, perhaps in collaboration with the folks here, that could have some value. But we're at a nascent stage on this thing, and frankly, I'm not sure what would go into that. Okay. But I don't think I'm not saying no, I'm not saying yes. I think it depends on the level of detail and purpose behind those temporary sort of guidelines.
Okay, I understand. Thank you for that.
Jocelyn, I'll just add, I do recall when the commission adopted its policy. I think that's kind of how it framed it with regard to settlement agreements. Okay. And I think that was done because that was a new day and age too. Yes. Where you had the birth of ORS, and ORS was facilitating agreements among utilities, and the commission was pretty clear that they wanted to have some sufficient time to kind of spend with the document before the actual hearing started. You're right. There was no regulation. There was no procedure on kind of how to handle that. And it was almost like a stopgap measure for the commission to do. So I think if the commission, I think it's certainly within their right and their discretion if they wanted to institute or discuss or pass or make some sort of policy generally like that. And then to your point, like Michael said, Dominion thinks that continuing to talk about this matter in a later forum would certainly be appropriate, and it may in fact be the right thing to do at this stage of the process.
Okay. One last question. If the commission places an item on the agenda, and so the public will have no less than 24 hours notice that it wants to visit Piedmont Natural Gas Company's, one of their gas plants. Do you think the appropriate way what would be your thoughts about including that as an agenda item, and then the utility can respond to say, okay, we think this is appropriate or not appropriate, unfortunately? How do you feel about that?
Are you in that? I want to make sure I understand the example. In that example, is that where the commission is more or less inviting themselves to kind of call upon or to visit? Well, a couple things. Number one, I would I would be hopeful that as part of something like that, the commission would maybe direct the staff to kind of reach out to the utility in advance to kind of coordinate that effort. I don't think that, at least Dominion, I don't think we would reject an invitation like that. I think really we'd want the notice to make sure we've got the right people available to communicate with the commissioners, make sure they understand how to ingress and egress. Safety comes up, obviously. So more than 24 hours notice might be necessary in that instance. So I think that might be maybe the better way to kind of handle something like that. If a commissioner or commissioners, whatever the case may be, may want to visit a facility, at the utility.
Okay. And
Ms. Boyd.
Yes, sir.
Ms. Boyd, could I add?
Yes, sir.
When Mr. Burgess is saying that we welcome the opportunity for the commission, et cetera, to come to that, the company does. But I think it's important to note that is in the context of my earlier comments that the company and the clear interpretation of sub I, this is not anyone can show up and take a tour if the commission wants to show up and take a tour type of thing.
Yes, sir.
And nor could it be. I mean, the act in no way can change the company security and access protocols.
Right.
So Mr. Burgess's point is accurate. I don't think it needs to be a very formal thing. If two commissioners want to come see Saluda Hydro pump storage facility, I think because you're exempt from the FOIA and is not an allowable, it is outside of the scope of the ex parte restrictions, you could reach out to us, say you want to do it, we'll arrange it, as Chad said, with ample time, and we can make it happen.
Okay. All right. Mr. Burgess and Mr. Anselmo, does that complete your comments right now?
Yes, ma'am, it does.
Okay.
Thank you.
Thank you very much. Okay, Mr. Wellborn for Duke Energy Carolinas LLC and Duke Energy Progress LLC.
Good morning, Jocelyn.
Good morning.
I might, in hindsight, have preferred the right seat, so I'm not craning my neck. But anyways.
Well, do you want to sit here?
No. Mr. Traywood offered the right seat, and I declined, but now I'm having second thoughts. Duke Energy Carolinas and Duke Energy Progress are really pretty optimistic about the statute and maybe slightly less wary, though. I agree that we'll need to handle it in the right way. And I appreciate you convening this workshop for us to kind of talk through some of the issues that we're identifying kind of at this early stage. The prohibition on requesting or seeking opinions or recommendations, et cetera, on ultimate and penultimate issues, it's the same language that we've worked with in the allowable ex parte briefing context. And so to me, it's it's different, but it's the same, I guess, in certain ways. As you're aware, and I probably many folks here are aware that the companies have already invited the commission to take a tour of WS Lee, and so we look forward to figuring out the logistics of that and how to make it work in the appropriate way. Like Dominion, we agree that we really don't think regulations would be necessary in this case. The statute is pretty prescriptive. Your idea of working on some procedures, just so we all know kind of the rules of the road, sort of in a functional or practical sense, makes sense to us, makes sense to me. We'll want to make sure that they don't establish binding norms, that it's more of these are our expectations, and that the commission and the party would have sort of discretion on a case-by-case basis to be a little flexible and to make things work. I think I was fortunate enough to take a tour of McGuire Nuclear Station last week and have been to WS Lee in the past. And just because they're different facilities, they have different security protocols, they have different, things are different on a case-by-case basis depending upon where the commission may find itself. And so some flexibility will be helpful, I think, as a general matter, even if we do have a set of protocols that sort of set forth, certain, I guess, overarching rules and that kind of thing. I don't necessarily have responses to each of these bullets.
Okay.
but happy to answer questions you may have. But in general, I think the main message is that we do look forward to figuring out how, so that we can, basically.
Yes. So the same question I asked of Mr. Anselmo and Mr. Burgess about revisiting this topic again, just next June to see how things are, or if we see that some more direction is needed. Are you okay with that?
Yeah, I am. I think that makes sense. Though I would say that hopefully we can, get a couple of these or under our belt between now and then, so we can see how it works in practice. Get some, some real life experience with it, and then, and then revisit maybe next year. In other words, I wouldn't want sort of next summer's, workshop or discussions to keep us from, from executing on the statute in the meantime.
Right. Okay. And do you agree with Mr. Burgess and Mr. Anselmo about if a commissioner or commissioners want to visit a site or want to request an educational tour, that we work with the utility and ORS to do that?
100%. Yeah, to me, it reminds me a lot of allowable ex parte briefing. So sometimes it's the utility or the party seeking something or asking for an allowable ex parte briefing, and sometimes it works the other way. The commission yesterday invited utilities to present on different Act 62 matters in allowable ex parte briefing context. And so to me, it works both ways. Like Dominion, because we're talking about, for example, plant visits, we'll want to closely coordinate on timing and ensure that the site itself has enough time in advance to prepare. So sometimes there are outages and things that could change the safety protocols and make things a little more challenging or different at the site. And so, like an allowable ex parte briefing, close coordination with ORS certainly makes a whole lot of sense to us, and of course commission staff as well.
Okay. So something staff has been working on, of course, we have Ms. Wheat, who's present at our allowable ex parte communication briefings, but Mr. Bachman's been working to try to figure out when our site visits or educational tours do occur, Ms. Wheat may not be able to be present. So he has reached out to ETV. We understand that there may be some security issues where we wouldn't be able to record, like video record, but staff is working on tools that we can use when and if these tours and educational sessions occur, so that we capture as much information as we can, so the commission is no one second guesses, really, is what we're trying to do, is protect the commission. So, okay. All right. The next, Palmetto Broadband Coalition. Hi, Ms. Edwards.
Hey, good morning. First off, thank you for the opportunity to participate. Our members are all telephone utilities with certificates of public convenience and necessity. Our members date, at least two of our members date back to over 130 years ago. We did do an allowable ex parte briefing just after, after May 12th. Yes. So after this and we actually considered whether or not, here at the commission, or how would we handle getting out the commissioners to our sites. Logistically, there, as many have discussed here, there are logistics issues on how you set that up, whether it's an educational visit or a site visit. Instead, we chose to bring a sample of fiber to the commission for the commission to view a sample of fiber. So that's and one of the reasons we did that, and you hit on it, is we didn't feel like we felt it was too new, and we didn't have guidelines. And frankly, the guidelines, as much for the commission, also help us, right, because we don't want to make a misstep either. Right. So like your thought of the guidelines, we don't really have a position on the regulation, no regulation. We just haven't looked at it carefully enough. But you are very welcome to come and visit. I will extend that on behalf of my clients. We would love to have the commission come visit us. Our utilities have been around for a long time. Yes. And that's really all I have.
So I'm not going to name the company, but they have, this was back way before 2005. I've been the agency since 1999. So there were two parts of our staff then, but I visited a telephone facility close to USC, and it was just interesting reading documents versus seeing co-located facilities. That's the part I'm looking forward to for those commissioners who've not had the same experience. So, I think there are some commissioners who've not been exposed to that type of tour, and I think it would be very helpful. So.
We would love to have you, and I do recognize. I think, especially the electric utilities have brought this up, but the truth is, it's unfortunately in the world we live in, security is an issue, and there are things to consider, but again, we would love to participate and whatever guidelines that this group and the commission ultimately decide are the best, we're happy to participate in that.
Okay. We ask that you keep your eyes open too, just for our discussion next June as we continue in this process, Ms. Edwards. Hopefully, if you see some things we need to change as we start this new process, we look forward to hearing from you. Okay. Mr. Burns with Carolina's Clean Energy Business Association.
Thank you, Jackie. Good morning. I wanted to just address roughly, I think some other participants are going to say some similar things. I don't disagree with the utilities that a full-on regulation may not be needed in light of the prescriptive nature of the statute. But I also think there needs to be something in the nature of guidance for a couple of reasons. And it's there are interested parties in almost all of the dockets that come before the commission, parties that would, under a ex parte briefing, be able to come and listen because it would be noticed and we would be able to see what was said and make sure that the topics covered are relevant, et cetera, et cetera. What would happen in a tour, if there's not guidance, we would need to be careful, let me put it this way, that a tour or a site visit is not a way around the ex parte briefing that's set out otherwise in the statute. There's a couple of things that and certainly I wouldn't mean to imply that we think that's what's intended here by the utilities. Clearly believe that they will try to and will comply with the law. But it becomes difficult when you look at the statute and you look particularly at section I-2B, where a summary of the discussion has to be produced and posted on the commission's website. I've been on a tour of a nuclear facility as a local office holder. Duke is very generous with their time and with their ability to give tours of the nuclear plant here in Wake County. And I know that line tends to stretch out a little bit, or you get in the control room and there are a couple of groups that break off. How do you summarize the discussion if one commissioner is over here asking a tech questions about what this machine does, and another commissioner is over there with a different person asking questions about how does this turbine work? That to me is a logistically difficult thing to do. And I also think that it becomes easier if the subjects of discussion are kind of limited going in. And I realize that section C says everybody will swear they didn't commit, predetermine, or predict anything. But I think it's important that the commission lay down some guidance at the beginning that says we will not discuss issues that would be otherwise the point of ex parte briefing pursuant to the other section of the statute. This is a special privilege, I would think, that if under what appears to be the prevailing interpretation of the statute, only utilities and the Public Service Agency get to do these tours of facilities, even though there are others that have facilities in South Carolina that produce energy and might be interesting to tour. There's no statute that sets that up. And so we need to be, I guess, wary of creating a workaround or an end around of the otherwise applicable portions of the statute related to ex parte briefings, because others don't have the ability to do that or give a tour of our facilities. Although I do think there could be some argument that the statute may apply to other facilities, but I think that that's biting off a much bigger piece than we need to chew today.
Yes, sir. So thank you, Mr. Burns.
I will. That's my main point as to how we hash that out or
Yes,
what
sir.
that guidance looks like. I think that's a good subject for discussion. I don't want to sit here and say this is what it has to say. I think that's something that we need to work out.
Yes, I agree with you. That is it. Kind of what you were saying or said to me. Kind of touches on what I was talking about. The commission staff is working on tools that the commission staff can use to protect the commission. I mentioned ETV has given us a quote for their videography equipment. I think it's a daily quote for daily estimate. And Mr. Bachman's even talked about how helpful an iPhone will be. But we are definitely, because staffs, that's what we want to do. We'll make sure we protect the commission and not have unnecessary or potential issues that could have been addressed, mitigated prior to.
And I want to note that I recognize the security issues as well.
Mm-hmm.
I'm not in the room, but I bet several attorneys just move forward in their seats when you have the idea of a camera in a nuclear facility.
Yeah.
Obviously, that's not something they're going to want to have.
Right.
That really comes down to that. Really, I guess, amplifies the difficulty of how to comply with subsection B.
Yeah.
I'm not sure how you get a summary of multiple discussions among several groups of people. It's just a logistical issue, and I'm open to discussion of how we address that. But I think some sort of guidance on the front end could limit what those breakout groups end up talking about. And that would make that easier to comply with.
So something I'm about to
that's
say.
all I have to add at this time.
All right. Well, I may come back to you, Mr. Burns. Something I wanted to add but I want your thoughts. I wasn't asking you to. I wanted your thoughts on what I'm about to say. We just talked initially, and it's not the entire commission staff and all the commissioners, but we were brainstorming this new statute. And one of the ways, for example, and we will continue to think about it, is what if the commission, all commission employees, commissioners, commission staff, there was one person who spoke if and when these site visits and educational tours occur. One person who spoke on behalf of the commission. Everybody else, basically, I don't know, we put a muzzle over their mouths, tape over their mouths, but we are thinking about those type issues too. When and if the site visit occurs or an education tour, only one person will be able to speak. If we've talked about, because I'm not telling you anything that relates to a particular case, so I feel confident in what I'm telling you. We talked about if we attend these tours, we all kind of need to stick together, kind of like when I was in kindergarten. You didn't go, if we went on tours, you didn't wander off. We stuck together as a group. So we've been talking about those type issues. You have any thoughts about not just what I just said, Mr. Burns, but that type of using that methodology where one person, for example, can only speak. If the person is an employee of the commission, that could be one way of addressing what you're concerned about. And I'm not asking, I know we're not going to solve this today, but I do want you to know we are thinking about those type issues.
Good. I think that's a good question and a really good effort at resolving one of those issues. I would want to hear the utilities' input on how that might work. Obviously, there's two sides to it, right? So only one commissioner or one staff member may talk under your proposal. How many people can talk to them? And when and about what subjects? It's really that latter question, I think, that most concerns us. And I assume good faith on the part of everybody here. But, I hate to have a gap through which things can be driven, and then we're struggling to to adapt or react to that. If at some point a site visit is treated as an opportunity to address an issue in a less than public forum and others can't really hear it. I don't think that would happen right off, and I think I appreciate what the representatives of the utilities here this morning have said about being cautious and making sure that we go forward in a way that complies with the law. I completely agree. I would think, though, that they would want a little bit of guidance in how to do that, so that there's not some situation where we suddenly discover something was discussed that should have been the subject of a ex parte briefing, and then we have to scramble to how to untie the knot. And so, but again, I certainly ascribe good faith to the folks here and to their companies, and I do think that they want to do this right. Having been on one of these tours, I know how educational they can be and how helpful they can be for understanding the scale of the operations and the complexity of the tasks that utilities have to deal with. So I would love to have. I think commissioners need to go in there and see some of these things, having done one myself. But I do want to make sure that it's not an opportunity to avoid the rest of the statute. And I'll be quiet now and defer to others.
Well, actually, I still want to come back to you, Mr. Burns, if that's okay. Because you brought up a topic that we haven't discussed yet. So I wanted to ask you about your experience, not details, but just generally. Can you tell me, was there an agenda, a written agenda, when you attended one or two of the site visits you've attended so far, a utility one? How many people spoke?
Well, let me answer that twice in two different ways. No, I've been on both sides of site visits.
Yes.
First of all, as a local office holder, I was a county commissioner in Wake County, and Wake County is the site of a nuclear facility for Duke Energy.
Okay.
And local office holders and state office holders are given the opportunity to tour, and they put together I don't know if it's annual or what, but during my 4-year term, I got one tour of the nuclear facility, and they talked about, they had us in a room and they talked about the emergency response that local government would be part of if something were to happen at that plant. But then they also gave us a walk around, and they had somebody telling us what we were looking at. Otherwise, I would have, my knowledge of it would have been limited to what I've seen in the movies. So they had an engineer walking through and saying, this is the control room. This is where we do this. That over there is the actual reactor, and it was the security requirements were such in a nuclear plant that we all had to stay together. In fact, there are yellow lines on the floor. Don't go past this yellow line, or bad things will happen to you. And which I appreciated. I didn't want other members of the public being able to wander around the nuclear plant. So it was very informative. It was sort of, we stayed together in a group. We went through security to get in. We went through security to get out. And I thought it was well run and very professional. I've also been on the other side in North Carolina, where as one of CCBA's members has a very advanced control room that controls all of their solar facilities in the Southeast. And commissioners were able to come in and see that control room, ask questions, and be told what that screen was, what this person's doing. And then we had a sort of a group discussion. And there were 2 commissioners there, not a quorum, and a whole bunch of their staff members were there just because they had never seen a control room before. So there wasn't so much an agenda as a sort of understanding of what we would be discussing and what they would be seeing. It wasn't like, here's topic A, B, and C. I do think it's helpful to have an understanding going in of what can be covered and what cannot be covered. And we were very cognizant when we were giving a tour of not addressing issues that were in pending dockets, et cetera, et cetera. Our ex parte rules up here are a little bit less prescriptive than yours down there. But we were cognizant of not talking about issues that were before the commission in any active docket. And as a commissioner, county commissioner, there wasn't an agenda of our tour as much as it was, we sort of had we knew we needed to be there at a certain time, and we knew that there would be a tour of the following parts of the facility, and then we would be done. We didn't really have but because I wasn't a decision maker on a docket, I think we had a little more freedom to ask questions, and because I was really just interested in security and what happens if there's an incident, stuff like that. So they wanted us to know a lot, and we wanted to know things, but I wasn't in the position of being a decision maker about any pending matter. So that's a little bit less relevant, I think. But all I can tell you is that it is an eye opener, and it's a great experience to walk through one of those things. And I would not at all have any objection to regulators seeing that, seeing what it is they're regulating. But I do think we need to be careful of topics discussed.
Yes, sir. Well, I appreciate you letting me ask you all those questions, but you visited. As
Yeah,
you
no
said,
problem. Happy to be here.
So
Thank you.
that's very helpful. Thank you so much.
Yes, ma'am.
Mr. Pelcher.
Good morning.
Good morning.
A lot of good things said here. Santee Cooper believes that promulgating a formal regulation at this time would be premature.
Okay.
Santee Cooper also believes that even issuing an informal guidelines at this time would be premature.
Okay.
As we read the statute, it's really intended to be self-executing. That is, the mechanics on how to do things are contained in the statute.
Mm-hmm.
Of course, over time, we'll have requests made under the statute. We'll learn more about it. I don't think that we could contemplate all the different circumstances where the statute may be invoked. Santee Cooper had a case recently where we had a surprise. Somebody thought maybe we ought to have a site visit.
Mm-hmm.
And then it caused us to think a little bit more deeply about this. So, we have the self-executing statute. Probably, there will be ambiguities and uncertainty discovered as we try to implement this in particular cases. As we get experience with this, it may be the case, maybe in June next
Mm-hmm.
year, that you indicate, or a future time where we might want to come up with some guidance. But that guidance, I think, would be informed by specific requests made for the tours and the site visits under this particular act. I'm going to turn to one thing in particular that has kind of concerned me about the statute here. Mm-hmm. This deals with the educational tour that we talk about in I-2. It talks about an educational tour of a utility or the public service authority plants or other facilities. I believe that when we talk about these educational tours, we really should be thinking in terms of something that is initiated by the utility rather than by the commission. I know that Duke recently suggested an educational tour of one of their natural gas plants, and it came from Duke, which is good. That would be different than if the commission decided we're going to show up and, we want to be educated on this.
Let me ask you this, Ms. Belcher. When you say they just show up, you mean unannounced?
No. But say we're going to show up in a couple weeks, or we would like to have an educational tour. I think a utility would be shy about saying no to the commission. Certainly Santee Cooper would be shy about doing that. But I think that we all, it probably should be the normal practice that the educational tour would be, the invitation would come from the utility, along with a description of what the scope of the tour as well, so that, as opposed to that coming from the commission. I do recognize that on the topic of allowable ex parte briefings, often those are requested by parties to the commission, but occasionally the commission suggests that you come in for an allowable ex parte briefing. And I think generally that has worked okay, even though if I read the statute, I would not it would not occur to me that the commission could ask for an allowable ex parte briefing. I would have thought that that would have to be initiated by a third party. And the reason why those generally work okay is that they're done right here in this room here. We have a transcript made. The Office of Regulatory Staff does a good job at making sure that everything is done properly so that statutes complied with. And we have all those controls involved. You would not have the same level of control with a educational tour that was really suggested by the commission rather than by the utility. So I think we need to really be very, very careful about that going forward. That's really the extent of my comments. Do you have any questions for me?
So I think what you're saying when you say that the tour, you're concerned about that is the controls that the commission or that may be exercised or would not be, could not be exercised if an educational tour takes place. Is that what you're trying to tell me?
It would be more difficult. And if it's initiated by the utility, if they extend the invitation there, the commission could always say yes, or they could say no. And the utility would be in a position to define what the parameters of the tour would be. Certainly could reduce that to writing, and it would give something for the commission to act upon. Of course, you've mentioned all the difficult issues about conversations that other people have during the course of the tour. That is going to be a real challenge. Those are the challenge there. I think will probably be should be worked out by the commission and the parties in connection with specific requests, specific invitations for educational tours, and I think we'll all be guided by that. So that's my comment there.
Yes. Yes. Well, would you be willing, with ORS present, if that issue arose, to sit down? If you're not telling commissioners, you would be telling staff. I think what we talked about earlier, perhaps this a request, if one is made, would not necessarily be on a commission agenda, but staff and I would make sure ORS is on the phone, if not me, someone else who's on staff, to talk to you informally about any concerns prior to. Would you be willing to have that conversation on a tour by tour basis?
Absolutely.
Informally.
Yes. Are we talking about a tour requested by the commission?
Yes, and I can assure you right now, I do not have that in my back pocket to talk to you and Mr. Mushton about at the end of this, I promise you. But I'm just trying to, if it arises, would you entertain a conversation with me and Mr. Mushton, for example, and where you can just, express your concerns or whatever about that request?
Absolutely.
Are you willing to start there to see? Okay.
Yeah, we'd be willing to do that for sure. And the conversation, the informal conversation would allow us to then think about, what the tour would consist of and some of the procedural issues. So it's done correctly. It's done in a safe way that doesn't disrupt operations. And it complies, most importantly, complies with the statute that the General Assembly gave us.
Yes, sir. Okay, well, thank you for that. That you will at least entertain a conversation if it arises. Okay? Okay, thank you, Mr. Pelcher. Ms. Eaton?
Good morning again.
Good morning.
I definitely appreciate the opportunity to participate in the workshop and for the idea that you had. I think everybody benefits from kind of sharing ideas and trying to collectively understand the new Act 41 language. I think that, everybody here so far has represented utilities and we represent Walmart, which is a regular participant in proceedings before the commission. and does have an allowable ex parte briefing scheduled for November 24th. And so come here kind of with that perspective. When you consider the allowable ex parte briefing rules and the language of Act 41, we believe that the language within Act 41 58, well, it's South Carolina Code Section 58-3-260I2 says nothing in this section prevents a commissioner, hearing officer, or employee from conducting a site visit of a utility or public service authority facility under construction, or attending educational tours of utility or public service authority plants or other facilities, provided the reporting requirements that are listed in I2 are met. And we observe that Section I2 does not add a qualifier before other facilities. And clearly, the legislature could have added utility-related facilities. And when you consider that non-utility parties do have an opportunity under the current rules to come before the commission to present on, have an allowable ex parte briefing, as long as the rules are followed, which thus far we have done to schedule our briefing and would intend to follow through with. I believe that it makes only sense looking at the plain language of Section I2 and reading the rules that the other facilities doesn't necessarily restrict these educational tours or site visits to just utility facilities or utility facilities under construction. And the reason for that, I think, one of the people that's spoken before, maybe Nanette, was when you think about the facilities that some of the parties that participate in the proceedings, the intervening parties, the intervening party groups, they also have facilities that clearly are impacted by various operations of the utilities, as well as decisions overall by the commission as a regulating body. And just as it might be helpful for utilities to go on a tour to see the complexity of operations at a utility, as well as the scale of what you might be talking about in an ex parte briefing, we would contend that it would be similar for certain customers where you might have facilities like Walmart does, that it's one thing to talk about it and use words and even pictures at an ex parte briefing, but it's a different thing to actually see it in person. And I also have gone on site tours, and I can say that a recent site tour I had back in May or June of this year at a Walmart distribution center, I have represented Walmart a long time, and I could talk about it and read about it, but going to the facility helps you much better understand the operation and how the electric service provided to that particular facility impacts the operation of the facility itself. And so no amount of words or pictures can do the same thing as the site visit. And I will say the site visit we had was controlled. There was a site manager, a plant manager, facility manager that led the tour. The tour groups were together. Nobody can wander off. The tour groups were limited in number of people, like say 30 people at a time. The manager's leading everybody around. Nobody in our group is, we're not asking questions, that person's kind of telling us what we're seeing and leading us around. And so you have, they provided us with a safety jacket, although most of because it was known in advance we were coming, and as long as you have enough advance notice to go through, the whole thing was very controlled. So I know that currently our client does have utilities, members of the utilities come to the facility to also see how it operates so that they also have that perspective. But given the language, really the plain language of Section I-2 of 58.3-260, we think that site visits or educational tours that are geared toward simply showing the commissioners what some of these third-party interveners or intervener group customers have in operation is very, very helpful and would be educational. And of course, the intent of an ex parte briefing is to try to have an opportunity to educate the commission. And this to me is a corollary. It's our position that it's kind of a corollary to that ex parte briefing, with the same rules being in effect. And, we're of course open to any suggestions for, limiting group sizes to a manageable amount of people, but open enough to make sure that ORS has representatives, the commission staff, however it would want to participate, members anybody who is participating in the allowable ex parte briefing could, of course, certainly also participate. We would just need to know, just like the utilities, you kind of need to know in advance numbers of people to make sure that that tours of that nature could be done. I mean, and potentially the tour could be audio recorded, not video recorded. But if it was audio recorded, then really you're going to hear the person speaking and leading the tour, which is not an advocate. It's the plant manager person talking about what it is you're seeing. So that's kind of the idea that we have, and we believe it would be every bit as beneficial to this commission as it would be to any of the members of the utility to visit the facilities to which they're providing valuable electricity that, our client counts on to be reliable above all else. So if you have any other questions, I'm happy to answer those.
So the tours that you attended where basically no questions were asked, but you provided information, did you still walk away feeling like this was valuable to me? It didn't really bother you at all that you weren't able to ask questions?
No, I thought it was highly valuable. I mean, I could talk to you all day about how one of these facilities is laid out, in words. I could show some pictures, but the scale of the operation, the need for specific controls in the facility, as far as, the operational control panels, all the conveyor belts, all the merchandise, you can't quite grasp the scale of some of these operations, and in turn what that type of facility would require from the utility that's providing the electricity for that, or potentially natural gas. But in general, I think almost all of them are electric. So I found it to be highly, highly informative, as would a tour of a facility. I know there was a time where the folks over at Dominion offered for us to come tour one of their solar facilities in Columbia, in this area, and that was very, very informative. I mean, just seeing it in person seeing how it was set up and arranged, it just makes what you're reading about and what we're talking about in the hearings make a lot more sense.
I think, thank you so much for your insight too. I appreciate that. And as we were talking about just controls and really, from my perspective, protecting the commission, the fact that, you know, I think that's another way to minimize the perception that something inappropriate is said or asked. If basically there's a lead tour guide and they do all the talking and everybody else just basically listens, and if need be, after that tour, someone maybe initiates an allowable ex parte briefing if questions need to be asked about the tour potentially. So
Right.
I hadn't thought about that. Yeah.
It's also, you said something about, you know, designating one commissioner. I believe that you would want one commissioner being in charge of the reporting requirements on the back end of any of these tours. It would seem to me, you know, they just take turns, whoever is going on it, you know, they amongst themselves decide. But that does make a lot of sense to kind of have that one person who's kind of the point person for the commission or commission staff. That way it's, you know, it's all funneled through one to kind of like to coordinate the site visit. Ultimately, we're coordinating that with a plant manager or a facilities manager. And once it gets there, they're running the whole tour, not any of us.
Right.
I would not have anything. I would not know what to tell you.
Yeah, I really appreciate your sharing your experience. That's felt helpful.
Sure, thank you.
Thank you. Okay, Mr. Terani, are you ready?
Of course. Freezing up. Can you hear me?
Yes, sir. I can hear you.
Okay, good. Lots of good thoughts today. I would start off by saying that I think it's important. Obviously, the legislature determined this was a good thing, that it would be useful for commissioners to have the ability to see these facilities, to learn about them firsthand. You know, I'm here for the Nexus Water Group's utilities. 20 years ago, I thought a sewage treatment plant was that big old thing off of I-77 with smokestacks and, you know, looks like a factory. You know, the first time I saw one of my clients' treatment plants, I was like, what is this? This is a pond. I mean, you know, I imagine, not all, but some commissioners may come to the water and sewer industry with that same lack of knowledge. Maybe they were in cities. Others might know more about that, might know less about solar facilities. So I think that's what the General Assembly was intending to address. And I think it's important that we honor that and not see it as a threat. So with that in mind, I think caution is warranted. Caution is a good thing. But we need to be careful not to overcomplicate this and not to make it overly restricted. On a side note, I agree with something Ms. Eaton said, that this statute shouldn't be limited to utility facilities. Other facilities only makes sense that term would be interpreted to govern the same major utility facilities the commission regulates through its siting process. So there's no reason to me that an independent generator's facilities should be excluded from the scope of the statute, and a reasonable reading of the wording other facilities would include that. It's not really a concern to my client today, but I think it's a general issue. I also think it's important to remember that the commission will still be governed by the Code of Judicial Conduct. There's nothing about these site visits that says a commissioner can have an ex parte communication. I mean, that's still prohibited. I mean, but it doesn't mean that we can overinterpret this. I think for instance, we take for granted there are a lot of assumptions about what is required for an ex parte briefing within the scope of the current statute. Now, I think it's important to note that an allowable ex parte briefing as allowed under 58.3.260 does not require a meeting of the commission. It could be conducted with an individual commissioner. It does not require broadcasting live streamed. These are all safeguards, and I'm not saying inappropriately, but that the commission has superimposed on the statute. As a practical matter, they're policies. They're not statutory requirements.
Right.
If you do an ex parte briefing at a federal agency, such as the FCC, for instance, it's not done that way. You walk into a conference room with a commissioner, with a staff attorney, and with your client, you speak to the commissioner and they publish a summary of the briefing after the fact. Now, I'm not saying that's what we ought to do, but I'm saying we take for granted that a lot of things that are being done right now are required by law, and they're not. So there is maneuvering room if a site visit needs to be done a little bit differently while still safeguarding against things like inappropriate ex parte communications. So I think a policy makes sense. We need to know how to go about this. If we want to invite the commissioners on a tour of one of our facilities, for instance, I kind of would like to know, I'd like to be able to go to the website and know what I'm supposed to do. And if there's a bullet point list that says call Jocelyn to arrange a date or whatever, that's fine. But it needs to be spelled out, so we're not just reaching for something. I think it's also important in formulating your policy that you distinguish between visits that are occurring during pending cases and purely educational visits, which would be more like field trips. It's one thing if, say, in a citing proceeding, the commission says, I want to see the facility, or I want to see the site of the proposed facility, versus just in the abstract, the commissioners are invited to tour a facility that is not part of any pending case. I think I think both are valuable. Both should have their place, just as sometimes juries might tour the site that's subject to a condemnation proceeding or a trial, whatever. I mean, these things happen even in the context of contested cases, but they obviously need to be handled differently and perhaps need more caution, more safeguard, more ability for parties to object, so forth, and probably different attendance standards. And again, I think the Code of Judicial Conduct helps you with that. And nothing in the statute does away with Code of Judicial Conduct. So in the middle of a pending case, a judge doesn't get to go out with the plaintiff and take a look at something and leave the defendant behind. On the other hand, without a pending case, a judge might be able to tour a facility someplace, or might attend the National College of Trial Lawyers, where he hears from plaintiffs' lawyers lecturing on one subject and defense lawyers lecturing on another. I mean, this is part of the process. We don't want people to be ignorant. I'm not sure FOIA doesn't apply here. If you have a quorum of the commission, I don't see anything in the statute. I'd be careful. I understand what Mr. Anselmo said, that there's FOIA explicitly applies in other places, but FOIA may very well apply to this. The question is, how does it apply? If you have a meeting of the commission, regardless of where it is, you have to notice it under FOIA. if an individual commissioner or less than a quorum of a commission visits a certain place, maybe the only thing that FOIA requires is that you provide any documentation of the visit. I don't think there's anything in FOIA that requires the public to be allowed to tag along in all cases. So again, we need to think about these things, but we don't need to get wrapped around the axle. Respectfully, I don't think it's practical to limit speech. to say, okay, only one person gets to talk and we're not going to allow questions. I really think that kind of defeats the purpose.
Okay.
I mean, if you're on site and you're looking at something and you don't understand what it is, you ought to be able to say, look, what's that? I mean, that makes sense. Now, the Code of Judicial Conduct probably says you shouldn't ask how much is that thing worth and should it go into rate base and what do you think the amortization period should be? I mean, but under any circumstance, you can't do that. So again, if ORS is present, if regulators are present, if other people are present, I think we can, and the commissioners and the utility are committed to acting lawfully, I think we can avoid these traps pretty easily. Sticking together, I mean, these things are common sense. You're touring a utility facility, we're not going to let people run wild. I mean, just like a pack of second graders wouldn't be turned loose in a nuclear plant. I don't think well, commissioners aren't second graders, but you wouldn't just let people go. I mean, of course, I mean, these are common sense. And recording, I think, while maybe desirable in some circumstances, I don't think is absolutely necessary or required. Again, the statute doesn't tell you need to do a recording. It just says you need to provide a summary, and it should be a fulsome summary, and it should accurately document what takes place. And perhaps if you're doing it in the middle of a case, you do need a recording. Maybe that's a different circumstance. Maybe you do need a court reporter if you want to do this during a case, because it's part of the record, and the rules of evidence, the rules of civil procedure still apply. So to conclude with this, I think this is a great thing. I think it's going to be helpful to all parties to have commissioners that are better informed, that understand things better, what they're ruling on. And I think if we all work in good faith to have this proceed, we should be able to do it. And I don't think you need a regulation.
Okay. Yeah, you said a lot, Mr. Torini. Thank you.
Well, my counsel in this proceeding gave me a lot to think about, so I had the luxury of coming late.
Yeah, I mean, I didn't mean that in a negative way at all. Yeah, points that I of course will continue to think about, and our team will, distinguishing between site visits that may occur during a pending case versus educational visits. And I know Mr. Anselmo mentioned earlier that the other sections, parts of 58.3.260 don't apply. For example, if a case is pending, an allowable ex parte briefing must be conducted at least 20 business days prior to the hearing. So that's something to think about. Should the same type guideline be followed for a site visit?
I think during a hearing, we need to really think about that. And maybe it should be just as a matter of caution. I don't know. It's really problematic during, I don't want to say problematic, because it could be useful, but I think it's got to be treated differently in a hearing. I don't think you could have, as a practical matter, we don't have, the only allowable ex parte briefing we would have during a pending case, about a pending case, is a public hearing, a public meeting that has a transcript and everybody sees. And that's why, and it still doesn't occur very often, but when it does, that's why people haven't gotten worked up about it. If a commissioner were to want to stretch the boundaries of the statute and say, I want to have my own ex parte briefing in the middle of, allowable ex parte briefing in the middle of a case, And no, I don't want the public there. And yes, we'll give you a summary of it, and we'll do everything that's required, by the letter of 58 through 260. I think you would run afoul of other issues, of other restrictions under the Code of Judicial Conduct. And I don't think and the two have to be read together. And parties would be well within their rights to object. And that meeting probably shouldn't take place. So obviously, you're just going to have to do it differently.
Yeah, that's and then you mentioned potential FOIA issue. We're gonna have to think about that too, because if a quorum of the commissioners are present, what type notice do we have to give? Yeah. So thank you and the recording issue. We were just really when we first, as you know, Mr. Terrain, because you were in this role when we first started the allowable ex parte briefings, and I don't think that Ms. Wheat was necessarily involved when we initially started this. I think people were kind of summarizing, so it's been very helpful having Ms. Wheat record, and also our live stream production team that's also another great value. So
yeah, I think it's great. I'm not objecting to it at all. And if you can do it, you should do it. I just don't think you ought to allow it to prevent a site visit.
Okay. Mr. Terrain, thank you.
You're welcome.
Mr. Hall, do you want to go next?
Sure, thank you. Good morning again, Jocelyn.
Good morning.
And I certainly thank the commission. Y'all are always very dedicated to getting parties together and talking through these issues. And as Mr. Terrain said, going last and sitting here listening, it's a lot more to unpack than it might have seemed at first glance. I agree with a lot of what's been said today. As Mr. Terrain said, the ex parte prohibitions still apply. Act 41 may have somewhat loosened them, or it may have provide some other exceptions, but they still apply. The Code of Judicial Conduct still applies. So I certainly understand, again, the commission taking a little caution with this and how to approach it. I agree with Mr. Burns and Mr. Burgess. This is new, and certainly proceed with caution. Don't have a whole lot to add on the other some of the other issues that have been discussed, but since you've asked folks about a regulation, I don't think one's required. From what I understand, maybe that your intent was, and if I understand it correctly, it's maybe to give guidelines to commissioners or other commission staff that would attend a site visit. Looking at the APA, it defines a regulation and an exemption. It does not include description of agency procedures applicable only to agency personnel.
Okay.
So I certainly understand if the commission wanted to provide some guidelines that staff or commissioners or others that may attend, it's a state agency. I think that would be fairly common practice for something like this. I do also think, not going to speak for the utilities, but while those procedures may not dictate what a utility does, I would think it would be useful to them to understand that, right? If they just some of the examples you gave, if all the commissioners will stay together and not go off in separate groups, well, that gives notice to the utility. Please don't ask, or you don't have to tell them not to do it, but they understand. Okay, if you ask them to go, off in a different direction, they're going to politely decline, perhaps. So I do think that could be useful. I think the last point, just based on what's been said, is that, while I agree that it could be helpful or educational, I do read Act 41 as applying these site visits only to utilities or Santee Cooper. We got a room full of lawyers. We could argue about the commas, lack of commas, and what applies to what. The way I read it is that that utility or other facilities goes with plants, which connects to utility plants or other facilities. I think otherwise you're opening up to what is a facility, I don't know, could you go to a mobile home park and see how folks there struggle with energy, keeping their homes, efficient? Could you go to a low-income apartment complex and see that people are struggling with the bills? I mean, I just think it opens the door to a wide variety of things. So I do read it as utilities. And I think that's really all I had right now. I appreciate the discussion. And if we have more later, I may have other comments.
Okay. Thank you, Mr. Hall. Mr. Richardson?
Good morning again, Ms. Boyd. a lot of good comments today. Not really sure if Piedmont has anything additional to offer.
Okay.
You know, continue to support the company's positions and the other positions offered by the utilities. But
Okay.
yeah, appreciate the opportunity to be here and participate and hear all this good lawyering. So
Thank you, Mr. Richardson. Okay, Ms. Mixon.
Good morning.
Good
I'm Kate
morning.
Mixon for Southern Environmental Law Center. A lot of the comments that we wanted to make have already been stated by others, including Mr. Burns, Ms. Edens, Torini, Mr. Hall. But just, in brief, first, we agree that there is a distinction between the issues that can be discussed in an allowable ex parte briefing versus what the appropriate scope of a site visit or educational tour would be under Section 58.3.260I. The ex parte rules are there for an important reason, and it's to ensure that the commission's decisions are based on evidence in the record and aren't improperly influenced by closed-door communications that are outside the view or scrutiny of other parties that are interested in the proceeding. And so there's a general prohibition on direct or indirect communications regarding any issue that is an issue in any proceeding or can reasonably be expected to become an issue in any proceeding without notice and opportunity for all parties to participate in the communication. And so there are kind of two pieces to that prohibition. First, around what can be discussed, and then second, who is able to participate or is able to see kind of the contents of that communication. The allowable ex parte briefing process as laid out in D6 provides the only exception to that general prohibition. Those provisions, as you're aware, are very prescriptive. And importantly, they're accessible to the public and to other interested parties who can either join in the hearing room or view the recording or the transcript after the fact when those are posted. The new provisions about site visits and educational tours don't require that other parties be afforded an opportunity to join, and the full discussion obviously would not become public, or at least not as, it's not a requirement in the statute currently. Instead, the contents would be provided only in summary form. And so we agree that the provisions about ex parte briefings and the new law about site visits and educational tours need to be viewed in parallel. In other words, you can't avoid the requirements in D6 for ex parte briefings by instead hosting a site visit or educational tour and then discussing those issues there in a less public forum. And so in our view, these site visits and educational tours should not be a forum for a utility to discuss issues that are in or are reasonably anticipated to be in active litigation or any litigation in a commission proceeding, and shouldn't be used as an opportunity for utilities to raise arguments that they are raising or plan to raise with the commission. And so instead, discussion should be limited to issues that aren't reasonably anticipated to be in dispute. Things like the location of different facilities, basic facts about how they operate, the status of ongoing construction, etc. It's a visit to the site for the purpose of viewing the site or for a high-level educational tour, not to move what would only be permitted in an allowable ex parte briefing to a less public forum. As others also noted, the Code of Judicial Conduct still applies, and so communications that could prejudice other parties in litigated proceedings shouldn't be permitted as part of these tours. We also agree with Mr. Burns' concerns about some of the logistical issues that could arise when certifying that there weren't any impermissible communications during a tour. I think there's a lot of ways that that could be addressed. Including, again, having video or audio of these tours where possible, or to the extent practicable, like other parties could be invited to participate in the site visit or tour, particularly if it involves a facility that is subject to active or anticipated litigation. And so in sum, we do support the commission having further discussions and developing some guidance on the front end about the proper scope of discussions and the logistics for these tours or site visits. We don't have a strong position about whether that should be in the form of a regulation or through a guidance document or some other means. But we do think that having clarity on those points will be important, and that at least until those are more fleshed out, that the commission and utilities should take extra care in conducting these visits or tours.
Okay, Ms. Mixon, you brought up some new topics too. Thank you. I like that you offered another discussion potentially. Maybe we can have a smaller focus group and then share what the focus group thinks about potential guidelines. And I'm not saying anything to cement it, but just something that would help us as we proceed under this new statute. You mentioned site visit purposes or educational tour purposes. In your opinion, that there shouldn't be issues that really aren't in dispute. There should be basically facts. This is a turbine. I don't know I can't think of another technical word, but they're fact-based site visits or tours. And if it's a tour, it's high-level educational tour. I guess that would kind of be fact-based too, Ms. Mixon. Facts that aren't can't be really disputed.
Yeah, I mean, I think that's right, and it kind of gets back to again the general prohibition on ex parte communications, and those relate to issues in any proceeding, an issue that is an issue in any proceeding, or that can reasonably be expected to become an issue without notice and opportunity to participate. Here, for these site visits and educational tours, there's not an opportunity for all parties to participate. And so we think that the scope of issues therefore needs to be limited.
So something else, excuse me, the focus group for me came to mind. We can talk about that after we take a very short break. But that came to mind, but then also when you mentioned if it's the commission employees who attend, and the Office of Regulatory Staff definitely will have to be there based on Act 41. Were you implying that perhaps we have a third-party witness? So someone who's not affiliated with ORS or the commission that kind of just is an observer? Were you saying that at all? Or did I misunderstand?
I wasn't quite saying that, although, I mean, again, that's another option. I think there are a variety of ways that the commission could handle, how to ensure that that communications are within the permissible scope. But what I was suggesting is that another option could be to afford other parties in these proceedings the ability to notice and an opportunity to join. Where it would be practicable to do so. And there would be a lot of cases where that would be, I think, quite difficult, yes, especially if it's something that may be anticipated to be in litigation, but which actually has not been opened yet. How do you identify who those parties may be? And then how do you kind of limit the number of people that are able to join to a reasonable amount. But it is something that I wanted to kind of throw out there. And it seems like an option that would be particularly important if there was a facility that was the subject of some active litigation.
So something else this focus group everyone could potentially do, I guess, is if the issue is pending before the commission, well, I think the commission would have to, though, provide, if a request was made or if the utility initiated it, the opportunity for the parties in the docket to provide an opinion, I would think. Anyway, if it's the case is pending.
And I think like that requirement wouldn't change the limitation in scope of what could be discussed at that tour. Because in our view, the only place where you can discuss these issues that are in dispute or maybe in dispute is in an allowable ex parte briefing with the requirements attached to those.
Okay. So how does everyone feel it is? Oh, wow. It's been an hour and a half. I apologize. Is everyone okay with us taking a 10-minute, is that okay, Joe, break? And then when we return, the Office of Regulatory Staff will be last for this round. And then I'll just go around and just ask if anyone has any other comments. Okay? It's okay if we return around 10:50, please. Thank you. Okay, everybody, we're going to get started again. If you recall, when we agreed that Mr. Mustian with the Office of Regulatory Staff would be next with his comments.
All right.
Mr. Mustian?
Thanks, Jocelyn. I don't think I've got anything additional. I know we've had lots of discussion. You know, the site visit section is pretty short, but there's obviously a lot of things to think through and consider. And I think our interest, at least, was making sure the commission was, and all the parties were thinking through all the different things that could arise and could come up. And so, you know, we've had some good discussion today about FOIA, about the other facilities, the summary, how we'll do those things. So, you know, I think all of those things are good for consideration and to kind of work through. Then to just kind of bring it around full circle, you know, with when Chad started off, it kind of made me cringe a little bit because he was talking about the allowable ex parte statute, and we've all lived under that, and you know, we've always been very careful to comply with that, and it made me start thinking that you know, I came to ORS in my first stint in October of 2004, excuse me.
Okay.
And right after Act 175, and so I think out of the people in this meeting, it was me, Chad, Charlie, and Jocelyn are the ones that have been here since the inception. Nanette came shortly after that. So, you know, and I remember, I can't tell you what the first allowable ex parte was about, but I can tell you, I vividly remember the wringing of hands and how we were going to comply with it and what all the different provisions meant. And so what I expect is that 20 years from now, we'll have come up with a procedure that we're all comfortable with and used to. I certainly hope that I'm not there here anymore. So I'll leave it to Elizabeth and Jason and Lyle and Sam, and Steve still may be here as far as I know, but in any event, I think this has been a good, healthy, and constructive conversation, and I look forward to kind of seeing how this all works out.
Okay. Thank you, Mr. Mustian. Okay, we're going to circle around again to see if anybody has any other comments before we conclude this morning. Mr. Burgess?
Jocelyn, I'll be brief in this final comment, and this really is just I know Walmart articulated its position related to the statute and how it interprets it, and I just wanted to let you know that Dominion doesn't interpret the statute in the same way that Walmart does. I do think that when you look at that particular code section that deals with other facilities, I think the phrase plants or other facilities clearly modifies the word utility and public service authority. So I do think that those tours are limited to utilities. The fact that Roger stated that same position, you should give that its appropriate weight, that we're in agreement with Roger on that. The other thing I would say to you is if that is the interpretation, that other facilities means that the commission can take tours of other customers, then I would submit to you that there would be nothing stopping me as a residential customer of asking the commission to come take a tour of my house to see my newly installed energy efficiency HVAC system or LED light bulbs. And I recognize that's a pretty absurd thing for someone to ask, a residential customer to ask the commission to come take a look at. But given the fact that residential customers certainly have the same standing as commercial customers and as industrial customers, I think that the interpretation would be equally applicable to those types of requests. And we mentioned earlier that sometimes the commission wants to initiate an ex parte briefing, and I don't think the General Assembly intended for the commission to invite itself to customers, businesses, or homes, especially when they don't necessarily regulate those entities. So I do think that the Code Section 2 here is limited to utilities and the Public Service Authority. So with that, Jocelyn, I just want to conclude by just telling you thank you. We really appreciate you opening the doors here today and listening to all the comments that we've been able to provide, as well as the other people's comments too. So thank you for that.
Thank you for participating. Mr. Welborn?
Thank you, Ms. Boyd. I don't have really too much more to add. I, like Mr. Burgess, appreciate the commission and you pulling this together. As I noted before, we are excited to take advantage of the new provision in Act 41 to invite the commission to visit our facilities. We think that would be helpful and educational. We just to provide any assurance or allay any concerns or fears. We have no intent to do anything apart from what the statute provides for. It defines issue pretty plainly and explicitly. It provides the same, restrictions on the types of communications as to ultimate and penultimate issues that the allowable ex parte statute has already provided for some time, as Mr. Mushin pointed out. And so that doesn't mean that we don't need to do it right. And do it in the right way and do it carefully. And that the first time around, we might, there might be a little hand wringing, but look forward to coordinating with the commission and ORS and figuring out how best to move forward.
Thank you, Mr.
Thank you.
Yes. Ms. Edwards?
Thank you. Again, I appreciate the workshop and all the thought and comments that have been shared. Some candidly not necessarily had come to me. Mm-hmm. So appreciate the opportunity to hear the comments. Again, on behalf of my clients, they're excited by the opportunity, and they also, again, we welcome some guidance and some kind of parameters. It kind of protects us too. Mm-hmm. And so we ultimately, however this proceeds, we would look to take advantage of the opportunity once it's available and that the commission is comfortable.
Okay, thank you. Mr. Burns?
Don't have a lot to add to what I said earlier, just to reemphasize that we think some guidance will be appropriate and helpful. Not sure a full-on regulation is required, and agree with my colleagues here on that. On the issue of what the term "or other facilities" means, I think that's a little bit beyond the scope of this proceeding. I think it's like many statutes, there's wiggle room for argument, and I don't think Mr. Terani is completely out to lunch on his understanding of that or his argument on that issue. I don't think it would necessarily apply to a person's house, but it may very well allow, for instance, an IPP, a third-party provider of power with an actual facility, to invite folks for a tour. But that's a question for another day. The tours themselves there needs to be some parameters, some written list of policies, not necessarily a full-on regulation, but here's how we propose doing this. What are your comments on that? And let's all follow these types of rules. But I do appreciate the give and take here, and thank you for the opportunity.
Thank you. Okay, let's see. Mr. Pelcher.
Thank you. And I agree that this was a very good dialogue we had today, very useful. I will say that on the words "other facilities provided" in I-2, that if you look at the language in the Act, it clearly applies to a site visit of a utility or C&T Cooper. And I don't know any other way to interpret that. I will say, with that said, I can imagine how and I was convinced Walmart, there may be and other entities, I could see value in those types of tours, for sure, even though I don't think that the statute currently permits it. I could also imagine that tours like that might be less controversial than potentially controversial than a tour of a utility facility as well. Having said that, I think that the General Assembly probably ought to address that and then probably put some parameters around it. Something that came, changing topics, during your colloquy with Walmart, a good idea came up, I thought, something to think about, the idea of an educational tour somehow coupled with an allowable ex parte briefing.
Mm-hmm.
And you didn't dive into that in a lot of detail, but when I imagined that, maybe a tour and then sequentially allowable ex parte briefing here.
Mm-hmm.
I think the commission has, and the Office of Regulatory Staff over the very long time they've been working on this, have really kind of buttoned up that allowable ex parte procedure. I know it's elaborate, a lot of parts to it, but all the ones I've been involved in clearly complied with the act and were done very professionally, working with the commission and the Office of Regulatory Staff. So it might be a way of addressing some of the concerns about statements that might be made during the tour. I think, going back to my original comment, we'll probably learn how to implement this as a result of specific requests made by utilities for educational tours. We are all looking to see how the one with Duke works out. That will be the test case. I hope everybody focuses in on that. Now, that will probably provide us with a lot of information as we move forward. Thank you.
Thank you. Ms. Eaton?
Thank you. I believe that to the extent that parties are in disagreement over the interpretation of the statute is potentially something the General Assembly should address, because when you look at Act 41, the overarching goals, allowing for greater transparency in proceedings before the PSC, it's not just solely utility focused. It's having expanding utility investment in and customer access to cost-effective DSM programs for enhancing efficient use of resources, promoting lower energy costs, mitigating the increasing need for new generation and associated resource, and assisting customers in managing electric usage to better control their electric bill. Well, all of those sorts of things are kind of more holistic. They're more educational. And so we would still maintain that in connection with an allowable ex parte proceeding or briefing, which we've scheduled pursuant to the current rules, a site visit of a facility, especially certain Walmart facilities, are interruptible. So to that extent, they help offset some of the utilities' need for adding generation if they can be called on when they're interrupted to provide standby power. So there are probably other customers of utilities who I think have participated in these proceedings, are well aware of the rules, are well willing to follow the rules set forth by the commission and any guidelines that I think that would further the education of the commission to be in a position to just view the facilities that they're talking about in these proceedings. So thank you. I appreciate the opportunity.
Yes, ma'am. Thank you. Mr. Tarani?
Yes, ma'am. Just briefly, I do think it's been a great discussion. Going back to this issue of, I just want to clarify, the statute says nothing prevents a commissioner, hearing officer, or commission employee from attending educational seminars or conducting a site visit of other facilities. It doesn't really, so it doesn't say anything about who has to invite whom. Now, I don't presume to think that the commission would invite itself to someplace, but a commission might express an interest in visiting a facility, and I don't see anything in the statute that prevents it from doing so. On this issue of the other facilities interpretation, I'll just say I expect until we get this cleared up, I expect the commissioners to stay out of Walmart, and hopefully we can figure this out as soon as possible.
Thank you, Mr. Tarani. Okay, let's see, Mr. Hall.
I don't have anything else.
Nothing else?
Thanks again. Always enjoy these conversations.
Yeah, thank you for participating. And then we have Mr. Richardson.
Same here as well,
Nothing?
too. Appreciate
Okay.
this opportunity and the series of workshops the commission's put together.
Yes, no problem. Thank you for participating, Mr. Richardson. Ms. Mixon?
Thanks, Jocelyn, and really appreciate the opportunity to be here. We don't have any additional comments. Thank you.
Thank you. And then we have Mr. Mushton.
Nothing further. Again,
Okay.
thank you for hosting this today.
Yes. So I think what I'm going to do is talk to the chair. Maybe everybody, we can just come up with, create internally at the PSC skeleton for some procedures for high level things or issues that we talked about today. And then we can share those on DMS. We've scheduled one other workshop for those of you who are interested. It's going to occur on October the 3rd, I think. It's that Friday on the customer complaint process at the PSC. That's out there under docket number 2025-191A. And there's just a suggested process there for you to consider if you decide to participate on October the 3rd. We are also working on using the comments that were made at the initial workshop to return to issues like the order of procedure in our regulations. There were some other issues regarding discovery, and the U.S. stakeholders made comments, and so we were trying to incorporate those into those regulations, and we're going to have another workshop. That will be the third one, right? But then maybe if you are interested, whatever we produce as it relates to some guidelines for the site visits and educational tours, if you don't mind participating in that. I'm not trying to hoard your schedule, but I think several of you you've mentioned some possible guidelines, and I just need to talk to the chair. I know he's listening. So we'll post those, and talk again if you would. Is that okay, Mr. Mushton? Okay. I really appreciate all of you. I think I've enjoyed the conversation, and it's always good to hear different perspectives. I enjoy to hear what Mr. Anselmo and Mr. Burgess, Mr. Wellborn, Mr. Trey, what you said, Mr. Richardson, from the utility perspective, but then also it's also helpful for me to hear someone who's not affiliated with the utility at this time, Mr. Burns, Ms. Eaton, and their experience. I think that was helpful. Even Mr. Terani, when he mentioned some things. So just the different perspectives today, I think are awesome. So thank you, and we'll see you the next time.
Thank you very